Good morning to you. In this session, we are taking up parliamentary procedure. Now there are two sets of clauses. One deals with the Constitution, Indian polity, and the other is parliamentary procedure. It may go together simultaneously or alternative days. We are starting now parliamentary procedure. Before going into parliamentary procedure, we should know something about the form of government which our country is following. As you know, we follow parliamentary form of government, both at the center as well as in the states. And what is parliamentary form of government? There is a fusion of legislature and executive in the parliamentary form of government. As you know, Union executive consists of President of India, Vice President, Council of Ministers, and Attorney General. So, what is the composition of Union executive? Union executive consists of President of India, Vice President, Council of Ministers, and Attorney General. All the four put together we say Union executive. Now come to the Union legislature. Union legislature comprises President, Lok Sabha, and Rajya Sabha. We find the President of India both in Union legislature and in Union executive. That is, he is part of Union legislature and part of Union executive. Here lies the parliamentary form of government. So here the fusion of executive and legislature. Parliamentary system of government is the one in which the executive is responsible to the legislature for its policies and acts. On the other hand, presidential form of government is the one in which the executive is not responsible to the legislature for its policies and acts. It is constitutionally independent of legislature with regard to term of office. Another important aspect of parliamentary form of government is that the members of Council of Ministers are chosen among the members of Parliament. Remember, members of Council of Ministers, that is the ministers, are chosen among the members of Parliament. No doubt, any person who is not a member of Parliament can also be inducted as a minister. However, he has to become the member of either House of Parliament within 6 months of his induction as minister, failing which he will lose the ministership. In the case of presidential form, remember, the president and his secretaries are not responsible to the legislature, nor they possess the membership of Senate or House of Representatives. That is the difference. The president can choose anyone as his secretary. On the other hand, in parliamentary form of government, the prime minister has to choose ministers only among the members of parliament. Remember, this is the major difference. Secondly, you should remember the parliament of government is taken as responsible government because the real executive, the Council of Ministers, is accountable to the Parliament. Under Article 75 of the Constitution, the Council of Ministers is responsible to Parliament and stays in office so long as it enjoys the confidence of Lok Sabha. Full stop. Remember, the parliamentary government is also called Westminster model, that is British, and it is prevalent in Britain, Japan, Canada, and India and other countries. The presidential form of government, on the other hand, is known as non-responsible, non-parliamentary, and fixed executive system of government, and it is prevalent in USA, Brazil, Russia, and few other nations. So, we have seen the difference between parliamentary form of government and presidential form of government. Remember, when we talk of President of India being part of both executive and legislature, the position of Vice President is unique. The position of Vice President is unique because the Vice President of India is part of executive. Just to see the composition, Union Executive consists of President, Vice President, Council of Ministers, and Attorney General. Even though Vice President is part of executive, he never performs any executive duties, rather executive powers. So long he is Vice President of India, he is only Chairman Rajya Sabha. What is his importance in the Constitution? His importance in the Constitution is that he acts as President when there is a vacancy occurs in the office of President due to his resignation, removal, death, or otherwise. In fact, he can act as President only for 6 months, within which period a new President has to be elected and he should be sworn in office. Similarly, when the sitting president is unable to discharge his functions due to illness or absence or any other cause, the Vice President discharges his functions until the President resumes his office. Remember, there are only 2 occasions when a vacancy occurs as a result of his removal or death, etc. But in that case, the election for the President has to be conducted within 6 months, and the Vice President will act as President only for 6 months. In another case, where there is a casual vacancy, in the case of absence or leave or he has gone abroad, etc., then the Vice President will act as the President and till the President resumes his office. Remember, most importantly, on both the above occasions, that is while acting as President or while discharging the functions of President, Vice President does not function as Chairman Rajya Sabha. And during both these occasions, he enjoys all powers, privileges, and immunity as applicable to President, and he becomes full-fledged President. In fact, he is administered oath of office as President of India. He enjoys under Article 361 all immunity and privileges, etc. Now, it is very interesting to know the Union Legislature consists of President, Lok Sabha, and Rajya Sabha. Here also, Vice President, who is the Chairman of Rajya Sabha, is not part of Union Legislature. See, Vice President of India is part of Union Executive, whereas he never functions as executive at any time. His only importance is when President is not there, then he will act as the President, whereas his original job is to preside over the sittings of Rajya Sabha. Even though he is the presiding officer of the Rajya Sabha, he is not part of Union Legislature, because Union Legislature consists of President of India, Lok Sabha, and Rajya Sabha. This is the very, very interesting situation as far as Vice President is concerned. Now, though we adopted parliamentary form of government from British Constitution, unlike Britain, Indian Parliament is not supreme. See, in the House of Commons is the most powerful chamber, because except changing a male into a female and female into a male, House of Commons is competent to do anything, most powerful. But Indian Parliament is not supreme. In fact, to be fair, our constitution has plenty of checks and balances. No organ of the state is supreme. We cannot call any of the organ of the state is supreme, because it consists of full of checks and balances. For example, let us say, can we call executive supreme? What is executive? Union executive? Union executive is Council of Ministers. Council of Ministers are always under the mercy of Lok Sabha, under the mercy of Rajya Sabha. In fact, precisely speaking, under the mercy of Lok Sabha. Lok Sabha can pass no confidence motion. It can defeat confidence motion. It can pass policy cut motion. It can pass adjournment motion. It can defeat thanksgiving motion to the president. By virtue of these, the Council of Ministers are obliged to resign. All the questions, half an hour discussion, short duration discussion, calling attention motion, all these things are keeping the executive on toes. So there is no question of executive being supreme. Executive is always subservient to the legislature and in the parliamentary form of government. Then let us say whether what is called what is the parliament in the the second one. Executive is not supreme. I have told you. Whether legislature is supreme. Tell me whether legislature is supreme. No. Legislature cannot, legislature in Indian Parliament, whether you call Parliament as supreme, no, it is not supreme. Under Article 121 of the Constitution, you cannot discuss anything about the judges of the Supreme Court and High Court except upon a motion for their removal. Secondly, Parliament cannot amend the Constitution concerning the basic structure. And many of the acts passed by the Parliament have been struck down by the judiciary, National Judicial Commission Act. So many acts which have been passed, including Constitutional Amendment Act, which have been passed by Parliament, have been struck down by the judiciary. So how can you say that this Parliament is supreme? So Parliament is not supreme. Now tell me whether judiciary is supreme. No, the question does not arise. Under Article 329 of the Constitution, the validity of any law relating to delimitation of constituency or allotment of seats to such constituency shall not be called in question. Number one. Similarly, Article 122, the validity of the proceedings of Parliament cannot be called in question in any court of law on the ground of any alleged irregularity. Under Article 74 of the Constitution, there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall exercise all his functions in accordance with such advice tendered by the Council of Ministers. The only option open to the President is to refer back any advice for reconsideration, and in the event of reconsideration of the advice by Council of Ministers, and if it is the same advice is tendered again, that advice is binding on the President. And most importantly, remember whether the Council of Ministers has given any advice. If so, what is the nature of advice? Cannot be questioned in any court of law. It enjoys, that is the immunity given to all cabinet decisions. The exception is only one, under Article 356 of the Constitution. If there is a malified exercise of powers by imposing the President rule, then the Supreme Court can ask the President of India to produce the reasons for imposing such President rule. That is the only exception. Similarly, under Article 77 of the Constitution, the validity of any orders or instruments under authentication of rules cannot be questioned. The question whether the validity, the authentication was done correctly or not, it is beyond judicial scrutiny. Similarly, the validity of the proceedings of Parliament cannot be questioned in any court of law. So nothing. It is completely there. The judiciary cannot question. Judiciary cannot question in all these things. And Parliament is not supreme. Executive is not supreme. Do you think that the constitution is supreme? How can it be? You have amended the constitution 103 times in 70 years. How can you say the and the 42nd Amendment Act, 44th Amendment Act, it has changed the complete narrative of the Constitution, of course, through enrichment. So, a Constitution which was amended for 103 times in 70 years, and some constitutional amendments are done in the morning, introduced, evening President has given the approval. How can you say Constitution is supreme? No, Constitution is not supreme. Parliament is not supreme, executive is not supreme, judiciary is not supreme. What does it indicate? Our constitution is fully balanced. All the checks and balances are included in the constitution. No organ has been given the powers. They cannot usurp the jurisdiction of other organs of the state. So, nutshell, the Indian Parliament is supreme in its own spheres. All are subservient to the constitution. Even constitution is not supreme because it has been amended under Kashal Singh versus government of UP, a most famous case. The Supreme Court said all are subservient to the fundamental rights. So the constitution is really supreme. However, even constitution has been amended very frequently, 104, 103 times, EWS, 103 times in 70 years. This being the case, none of the organs of the state is supreme. Every organ is subordinate to the other, and there is a limitation. There is a check in the inherent in the constitution itself. With this, we will complete the class today. From next class onwards, we will start parliamentary procedure. Thank you.